Hello, my name is Christine Thornhill, and I am a family law attorney. I've been practicing for nearly 20 years here in Central Florida. We're here today to talk about when can your child decide that he or she does not want to go visit with the other parent. So my short answer is that a child cannot decide that they don't want to go visit with the other parent until they're 18 years old and they're not a child anymore. So it's a parent's obligation to make sure that they're fostering a healthy relationship between their child and the other parent. Because one of the best interest factors that we've gone over in a previous video discusses is the parent fostering a healthy relationship between child and the other parent. And you want to be able to tell the judge that I am encouraging my child to go see the other parent, to go visit with the other parent, to communicate with them, to answer their phone calls. I'm encouraging that. You don't want to be on the side where you're being accused of telling your child, well, you don't have to go see dad, or, well, if dad's not listening to you, then you don't need to go over there. Or if you stay over here, then I'll take you shopping and we'll go to Disney. So why don't you not go see dad so we can do something fun this weekend? That is not something that you want to be accused of. And that's definitely not something that you want to be happening that can come up in court. So first of all, you want to encourage a healthy relationship between the parent and the child. However, it's going to be a lot easier to pick up a 2-year-old or a 3-year-old and put them in the car seat, strap them in for during an exchange, and letting them go with the other parent. Sometimes kids or babies have that separation anxiety. Some parents have that too, but when your child is kicking and screaming and won't let you go, you as the parent can take the child off of you if it's 2 or 3 years old, put your child in the car seat for the other parent, strap them in, and let them go. Because most of the time, sooner or later, and maybe even just 5 minutes after being out of your sight, the child calms down and everything is fine. And then that parent can enjoy time with their child versus a 14-year-old, 15-year-old who just does not want to go to the other parent's house. And it could be for no other reason than maybe they would rather go over to their friend's house. They don't really want to spend time with the parent that they're with, but they just want to go over to another friend's house, or they have a sleepover going on, or a birthday party, or a basketball game that they want to go do. And so they don't want to go to the other parents maybe that weekend, or maybe for a couple of hours. It's the parent's obligation to encourage that relationship. However, it's a little more difficult as your child gets older and gets more mature and starts having a mind of their own. A lot of parents will wonder, well, when can my child go into court and tell the judge, I don't want to go with the other parent for a visitation? And that's a very tricky point, because there's a lot of confusing statements out there, or bad advice. People will come into my office at least and say, well, my child's 15, so now my child can go in front of the judge, right? No. Or my child's 16 or 14 or whatever number you come up with. And that's not how it goes. There is not a specific number that allows your child to reach so that way they can go in front of the judge. It's not based on a specific number, unless you want to say that number is 18, because at 18, of course, your child can decide what he wants to do or she wants to do, because the child's no longer a child. There are ways where a child's position or beliefs or well-being can be brought forward without having the child come into court and testify, because most judges don't want a child sitting in a courtroom between mom on one side and dad on the other and going, well, I don't want to go to that parent, or I only want to spend time with this parent, or this is bad over here, I don't want to. A lot of judges don't feel that it's in a child's best interest to be put in a position where they're in front of both parents and having to say, I love this parent, or I don't love this parent, or this one's more fun. It's just not a good situation. So there are a lot of ways around that where your child's position or your position can be heard in front of the judge without bringing your child into a courtroom setting. And that could be through a guardian ad litem. So a guardian ad litem basically goes and interviews the child at mom's house, goes and interviews the child at dad's house, goes and visits the child at school or an after-school activity. Maybe they're in Taekwondo, so the guardian ad litem will go over to Taekwondo so they can talk to the child, not on mom's turf, not on dad's turf, but in the child's own setting, and kind of figure out, well, where's the stress coming from? Is it at mom's house, or is it at dad's house, or is it something that the child is going through that neither parent know about? And then the guardian ad litem has an independent investigation to come up with a report and go in front of the judge and say, this is what's happening at mom's house, this is what's happening at dad's house, this is how the child's feeling. So I, as the guardian ad litem, believe that it is in the child's best interest for this to happen. And the guardian ad litem doesn't exactly or per se have to update the court as to what the child said, but based on the factors and based what's going on, it's a little different because the judge will never leave the courthouse and go to mom's house or go to dad's house or go to the child's school, but the guardian ad litem does. And the guardian ad litem can give an independent opinion, recommendation as to what is in the best interest of the child, so that the judge can then say, okay, this is how I see it now, and this is what I want to go with. Or the judge could also go, well, I agree with the guardian ad litem on these points, these I differ on, so this is what we're going to do instead. And it sometimes helps the situation because parents get to see not only their views, but what the guardian ad litem brings to the table also. Sometimes you have a child who absolutely, I have to talk to the judge, I want to talk to the judge, and is very adamant about it. And so parents feel that they need to at least put that out there so that way they can satisfy the child's needs and concerns. So you would file a motion for child testimony. And you can do that by alleging that the child is of sufficient maturity and that the child knows about the events that he or she is going to be testifying about and has an opinion about them that is relevant to the case. And if the court then decides that the child is of sufficient maturity, knows the difference between right and wrong, and can advise the court on certain issues that are present before the court, then the judge might leave mom in the courtroom, leave dad in the courtroom, but take the child with a court reporter, so that way you have everything being recorded, into chambers, and that way the judge can ask questions to the child to find out exactly what's going on and where the child is. Or maybe it's not even asking any questions to the child, except, okay, what did you want me to know about what's going on? And that can be really important. It could also be allowing your child to come off of some of the stress, and a stress reliever by at least feeling that he or she has a voice that is being heard by the judge in a family law action that normally the child doesn't have much say in, because time sharing, custody, those are parenting decisions that are normally don't involve what's going on with the child. But sometimes when you have parents that are divorcing and the child is 16 years old, maybe about to be 17, and yes, each parent wants to spend equal amount of time with the child, but sometimes the child doesn't want to spend equal of time with either of the parents. The child wants to go off with friends and or maybe is very big into sports. So the child needs that time where he or she is not required to do a visitation schedule or a time sharing schedule. So you really want to take into consideration that, because there is not a specific 15 years old or 16 years old when your child can go into court and say what he or she wants. And again, we can go through all of the steps of, we can either do a motion for a child testimony, you can get a guardian ad litem that has to be paid in family court by one of the parties, or you kind of can work that out in through mediation. I hope that today answered your questions, and I look forward to talking to you next time.